Today we're going to be talking about 3 ways to give gifts in a will. My name is Gregory Singleton. I'm an estate planning and probate attorney located in Minneapolis, Minnesota. I work for Signature Law, which is a estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. If you like today's video, please feel free to like and subscribe below. It sure helps support the channel. Otherwise, let's get right into it. 3 ways to give gifts in a will. So this is going to get a little bit heady. It's not as obvious as one may think, but I'm hoping what will happen with this video is you'll understand the structure of a will a little bit better, so when you go to talk to your attorney, you know what they're talking about. You can put some thought into these things beforehand, and it can make the whole process a little bit smoother of setting up your estate plan. So, without further ado, there are 3 basic types of gifts in a will. There's a special gift, a general gift, and a residuary gift. A special gift, an example of that is giving my computer to someone. General gift is giving one of my computers to someone, and residuary is giving my stuff to someone where my stuff just so happens to include a computer. A special gift, the definition of it is a specifically designated item that can be identified in the language of the will. There's 2 ways to give special gifts in a will. One is directly in the will and one is by the addendum. Now in the will, once you put in a provision that says, I give my computer to Bob, it's in there until you rescind the will and re-execute a new will or amend the will. So it's a pretty set in concrete situation. The addendum is something that we have in Minnesota, which I think is pretty slick. You have your will, it's all completed, executed, and everything, and then you have the proper language in there authorizing an addendum, of course, make sure your attorney does that. And then you have a document that you can handwrite or you can type up and sign, make sure to date it, and in that addendum you can write, I give my computer to Bob, and then you slap that on the back of your will, and then tomorrow, the next day, you could change that and say, I don't want to give my computer to Bob, I'm going to give my computer to Susan, and you can rewrite a new addendum, rip up the old one, slap the new one on the back of the will, and it's legally binding. So you can change your specific gifts in a will on a regular basis as life goes on. So it's kind of a neat way to work. I recommend that people use it as much as possible. One concept to be aware of is called addemption. And this is when a specific gift that's given in a will lapses because it's not in the estate. For example, I want to give my wedding ring to my son, for example. Let's say his name is Bill. But by the time I die, I've already given my wedding ring away to somebody else. In Minnesota, what happens is Bill gets a substitute gift or he gets nothing, depending on what the court thinks is appropriate. Now, if I've already given my wedding ring to Bill before I died, that's called addemption by satisfaction. He doesn't get a substitute gift because he already got the item. What you can do in the language of the will, or in the addendum, of course, is you put in specific language for what happens if there is an addemption. You put in language that says, I give my computer to Bob, but if my computer is no longer in my estate, then Bob gets a puppy dog, or then Bob gets nothing, whatever you want Bob to have. The reason you do this is it makes family harmony. There are a fair number of fights about what happens when something has been deemed in a will, and we want to try to avoid those fights. So a general gift. Now the definition of a general gift is it's a gift that where someone gets a specific amount of money without the money actually being identified, or gets one of many things. And the most common general gift is giving a specific amount of money. Say, I give Bob $10,000 in my will. Now, if you were to say, I give Bob the $10,000 that is in my wall safe, then that's a specific gift. And I'll tell you why it's important to determine what is a specific general and residue gift in a will in a little bit. Here's a pitfall that you can run into with general gifts is if you think of stock. If you're going to give out, let's say 100 shares, let's say you have 100 shares of Apple stock, and you want to give Bob 100 shares of your Apple stock, and you don't die for another 20 years. And by that point, the Apple stock has split. So at that point that you die, you have 200 shares of Apple stock. So what does Bob get? Well, Bob is going to get 100 shares of Apple stock, even though it's split since the time you wrote the will. The other 100 shares of stock is going to fall into your residue, which we'll talk about in just a moment. So if you want to make sure that Bob gets all of your stock, work with a percentage. Say, Bob, I give Bob 100% of my shares of Apple stock, or a smaller percentage, whatever you feel is appropriate. Another pitfall to be aware of, it also is a pitfall for specific gifts, but primarily for general gifts, is people that are on medical assistance, such as Medicaid, which is the federal program. In Minnesota, we call it medical assistance, or someone that has a disability is on some other state or federal program. To be eligible for those programs, you have to have a minimum amount of assets in your name, and then a minimum amount of income. I think the minimum amount of assets is as low as $3,000 in Minnesota. If you give them a general gift of, say, $100,000, all of a sudden they are no longer eligible for their medical assistance, and you can screw up their benefits, and they'd have to reapply down the road, and it causes a big hubbub. What you can do to get around that is make a testamentary trust or use a revocable living trust to put the funds in a trust for them. There are certain things called Medicaid trusts or special needs or supplemental needs trusts that can be used, that can give money to them in a limited capacity for what they can use it for, but they still get the funds to help with their health, education, maintenance, and support without losing access to their benefits, and that's very important. The final type of gift in a will is called the residue. And the definition of this is just whatever's left. If you haven't given it as a specific gift and you haven't given it as a general gift, it falls into the residue. If you haven't specified anyone to receive your residue, then we look at the intestacy statutes of Minnesota or whatever state you're in, and we follow the hierarchy of who gets your stuff. There is a law that basically says if you don't have a will, then this person gets your stuff, and if this person doesn't exist, then this person gets your stuff, and then that person doesn't exist, then this person. I think it goes spouse and kids, and there's a calculation that happens with that, and then if you don't have a spouse, then it goes your kids, and it goes your parents, and then it goes your parents' children, et cetera, et cetera, et cetera, down to your kin. So make sure that you have at least one person listed to receive your residue. Otherwise, or multiple people. You can say someone gets 50% of my residue and this other person gets 50%, or you can say this person gets my residue, and if they aren't alive at the time of their at the time that I die, then either their descendants can get it, or then this other person gets it. We've already talked about the stock. What'll happen if you give 100 shares of Apple stock and the stock splits? The existing stock that isn't given to Bob falls in the residue. This is the residue we're talking about. Generally, when you're giving residue, you give a percentage of the residue, either 100% or a smaller percent. Just make sure it adds up to 100%. So there's a few pitfalls with gift giving that you should be aware of. The first one is leaving gifts to a minor. In Minnesota, a minor who is under the age of 21 cannot receive a gift. They have to receive it in trust until they are of the age of majority, until they are 21 or older. If you don't create a trust in your will, which is called a testamentary trust, then the court has to make that trust. And that's a huge bureaucratic nightmare. It's very expensive. You have to get attorneys involved. It's going to eat into your estate. So when you're setting up your estate, if there's a chance that something is going to go to a minor, make sure you set up a testamentary trust and talk to your attorney about doing that. Another mistake that people make is having what I call the decider. Say, for example, they want to give all of their property as residue to their nieces and nephews in equal shares, or in some sort of shares that are not necessarily equal. They give it to Susan, who's one of your aunts, or maybe your sister, and say, Susan, I'm giving you this stuff to distribute to all the nieces and nephews, and I'm going to let you decide who gets what. This is a recipe for disaster. It's a recipe for fights. Susan may decide to give everyone an equal share. That might be the fairest way. However, you may have some people say, look, I just went into the hospital for heart surgery. I need some extra money to just survive on. I think it's appropriate that I get more money. Susan might not, it might be more appropriate for Susan not to give equal shares to everyone. Or Susan could play favorites with her kids and not with other kids. You never know how it's going to work out after you've died. So it's better to take the time and distribute things in your will, set up trusts as necessary, and do the work yourself, as opposed to just punting it to someone else. Another pitfall that people run into is math. Attorneys tend to be pretty terrible at math. Make sure all your percentages add up to 100%. You certainly don't want them to add up to more than 100%, but even adding up to less than 100%. What I'm talking about is if I were to give 30% of my residue to Bob, 30% of my residue to Susan, 30% of my residue to Bill, well, and that's it. Well, there's 10% of my residue that's unaccounted for. What the court's going to do with that is up to the court. So you want to make sure you take care of that and make sure the math adds up in the first place. The final thing to keep aware of is when giving a gift, and this is usually for a special gift, possibly a general gift, but I think more for a special gift, is the concept of exoneration. This is giving property subject to a mortgage. Do you want to exonerate it or not? Meaning that if you have a house and you want to give it to your brother, but it still has a mortgage on the date that you die, is the mortgage going to be paid off by the residue of the estate, or is the mortgage going to be paid or given subject to the mortgage and then your brother will just have to refinance? That's a big question because there can be a lot of money at stake. Make sure you specify whether the mortgage is paid off, and if it's not paid off, what will happen to that mortgage. One final concept I want to talk about is abatement. This occurs when a will contains a gift that exceeds the value of the estate assets available to satisfy such bequests. For example, I wish I had my whiteboard here, but I don't have it. I don't have my trusty whiteboard today, so we'll do this in theater of the mind. Let's say you give your guitar collection to Joe, $100,000 to Bob, and the residuary of your estate, which you expect to be about $50,000, to Susan. You also have $60,000 in debt. So how do we deal with this? Well, we satisfy the gifts in order of special to general to residue. So first, and you satisfy the debt in reverse order. So the $60,000 debt is first going to be paid by the $50,000 in residue. So Susan's going to get nothing. Then the remaining $10,000 of debt is going to be satisfied by part of the general gift that was given to Bob. So in Bob, instead of getting $100,000, will only get $90,000. Now the guitar collection that goes to Joe, he's going to get the whole guitar collection no matter what it's worth. This is under statutes. You follow the statute in Minnesota. I think it's 524 3.902. I could be wrong on that, but I think I'm right. But moral of the story is it follows the hierarchy of who gets the hierarchy of gifts. So residue goes first, then general, then special is protected the most. So that's that. That's the story of how to give gifts in a will. I hope you liked today's video. If you did, please be sure to like and subscribe below. It sure helps support the channel. If you have any questions, leave them in the comments below. Otherwise, until next time, this is Gregory Singleton with Signature Law.